Hey, I have a client who is actually lodged at the Hart County Detention Center. I was wondering if it'd be possible.
Greg,
Yes.
I don't know if you can communicate with Miss Myers, but our Hart County, they wanted us to move that person to 1 o'clock. So we had a 10 o'clock, but we moved it to 1 o'clock to accommodate the jail.
Okay. Well, do you remember his name?
Brandon Coy, COY.
Oh, okay.
I don't know
I'll
if that's what, I just heard her calling there and I don't know if that's what she was calling about, but
Probably. I'll call her and let her know.
all right. Put my video on here. Very good. All right. Good morning, everybody. We're going to get started on our criminal docket, the morning docket. I have a request from the folks over there in the Hardin County Detention Center or Hardin County Jail that we do their 2 cases first because they've got some time issues. We've got Mr. Wolf and Miss Bryant. The problem I see possibly with Miss Bryant is that I think a private attorney may have entered an appearance, which means if nobody told that gentleman that we were moving her, then he ain't gonna know. Oh, okay. All right. I didn't see him on here, so. All right, so let's address Mr. Wolf. This is 20 CR 319. David Wolf. Hello, Mr. Wolf.
Hello.
Hello.
Mr. Barry, is this your case?
Yeah, this is mine.
Oh, okay. All right.
Judge, I think we might be close to a deal in this case. I sent Mike a counter offer this morning. He got back to me on that. If we could push this off 1 more week, I think we can possibly get this thing resolved. I think we're close.
Mr. Wolf, let me ask the fellow that's there with you what their schedule is like. I don't know if next Monday will work for them or not.
What time are we looking at? Same time next week?
Yeah. Yes, sir.
Right now, I do not have nothing at 10 o'clock.
Okay, so if we gave it another shot next week, you all should probably be able to do it. Is that fair?
Yeah, the only thing is Mondays is my family court day, and that's what I've got to get to at 11:15 this morning because they only give us like a 10-minute time slot to get there or you're out of luck.
I understand. What I could do, I could tell Mr. Richardson and Mr. Spears that if you all have an agreement and you all will let me know, I could try to start, I do a docket before this and usually then I come in and start this one at 10, but I could try to do this case prior to 10 o'clock if, like maybe 15 minutes till or 10 till or whatever to try to help with the time if you all warn me ahead of time that that's going to work. Is that a fair way to do it?
Yeah, that'll work for me.
All right. So we'll send you a link, sir, but it's the same link that you've been getting every time. So if you just wanted, your link will say 10 o'clock our time, it'll say 11 o'clock your time. But if you just want to jump on there a few minutes before, then we'll try to accommodate you. Okay.
All right. Sounds good.
Okay. All right. Thank you.
Have a good day, sir.
Yes, sir, Mr. Wolf, you too. The other case that we've got with you folks in Hardin County, it's Miss Bryan. Her attorney is out of Louisville. He's supposed to be on here, but he's not on here. And under the circumstances of them being on a short leash, I don't know how long we can wait.
You're posting gloves to Oakland Court for these guys.
Well, I had to give all my shit up to them. merit job on the poor. Give everything I had away.
I'm gonna have to call and place an order.
They give me a box of each. What do you think?
Hey, Mr. Sneed, we're gonna have to get you on mute, my friend.
Oh, I'm sorry, sir. I didn't know I was, you could hear me, sir. Excuse me.
Luckily,
Let me
you didn't
figure out
say
how to
anything
mute.
too bad. Well, I'm gonna mute you,
Oh,
but you'll
no,
have to, I'm muting you. You'll have to unmute yourself in a minute. No, because they can't, I mean, by the time we do all that. This is Miss Bryant, her attorney out of Jefferson County has filed a motion for a evaluation under Chapter 504. I don't know, I guess, Mike, are you doing this one?
I am, Judge. I read the motion, and essentially what I saw was he was wanting to, I guess, have her evaluated by KCPC, I guess, as far as determining competency and I guess criminal responsibility too. But she, I kind of wish she was on here. She's got, and we talked about this before, multiple other cases and one set for trial. I mean, I doubt that's going to happen. I guess it's set for March the 15th. I can't imagine. I mean, it's Franklin County, but I can't imagine they're going to do anything. But kind of would like to know what's going on with the other cases before we proceed on that.
Well, I anticipate that he's going to join the call at some point. And it's very possible that we can talk to him about that. We won't have the benefit of having Miss Bryant on, and,
Right.
She's entitled to be present for any kind of hearing that we have. So we'll just discuss with him, and then possibly we may have to bump her over to next Monday as well, if
Sure.
it's something that we need to actually litigate, so to speak.
That's fine.
If he tells you something and you, at that point have enough to say you agree with it or whatever, that'll be different, and we could probably do it without, because it would just be a
Right.
matter of entering an order, and she wouldn't have to be involved in that. But
Yes, sir.
Ms. Bryant, do you understand what I'm saying?
I believe so. You said next Monday or?
Your attorney is just a few minutes late getting on here, and he probably didn't, I can't hold him responsible for knowing how quick we were going to do this one. But when he does finally join us, if he does, we'll talk to him about what's going on and about his motion. And if we have to have an argument about it, we'll probably do it next Monday when you can be present. Okay.
Okay.
All right.
Thank
So
you.
same deal with, as we did with Mr. Wolf. We'll do that when it's close to, let's say 1:45 or 10 minutes till 10 o'clock or whatever, which is 11 o'clock to you guys in Elizabethtown. Okay.
Okay, thank you.
All right. Thank you. I'm not going to do anything yet just because he hadn't shown up. All right. Thank you very much, sir.
All righty, thank you.
All right, let's go ahead and get the Barron County Detention Center in here. Do you all have any preference of the order, or do you want me to just go alphabetically like I normally do? All right. Megan Brooke Ballard.
I believe that's mine, Judge. She had a new arrest recently, and I can't remember.
Mike, that was sent to me as far as Darlene.
Oh, okay. Never mind.
I've just signed the motions and I've e-filed those this morning,
Okay.
or actually as a supplement.
Yeah, I think I confused her with somebody else. Huh?
All right, so Mr. Gardner, your motion is, these are probation cases, right? So it's a motion to revoke probation. You already had a motion pending due to an allegation of absconding, right? So you just supplemented that?
That's correct. I supplemented this morning.
All right. Mr. Denise may be the person to ask. I don't know. I believe Bruce Brown was doing this one when it was first before me because of a conflict. So will he be the person that will be handling these motions, or will it be somebody else?
I will have to look to see if it's still a conflict for our office, but probably Bruce will get it back.
Okay. Let me just say then that I will need to, we'll need to make sure that Mr. Brown gets copies of what we're doing.
Is this a probation revocation, Judge? or
It
bond?
is, it is.
Okay, I don't know if we'll send that to him or not. That's okay. Go ahead and send it to us and we'll look at it and see. We may do that in the office.
Yeah, I honestly can't, I'm looking at the various indictments. I can't tell you whether or not
Okay,
there's still a conflict or what.
that's fine.
Sure, sure, yeah. All right. So, Mr. Berry, these will be, because of that question there, I think we're gonna have to do these on the 23rd, March 23rd.
Okay,
March 23rd at 1:30, okay? Thank you. Our next case that we have on the list is Mr. Britt. Mr. Britt has a sentencing. I don't know if he's had the chance to look at everything that he needs to look at in that case.
Judge, I went over his PSI with him this morning. So we should be good to go.
All right.
I don't
You all
think I ever
prepared?
got his PSI.
I'm sorry?
I don't believe I ever got his PSI. I'm trying to look at my
Oh.
email now. Yeah, I saw the other assessment, but
Well, would you like to come back to him and we can email you this PSI and let you look at it?
I just need to look at it real quick, Judge. That's all I need to do.
All right.
Your Honor, I guess we need to address that at this point. I don't think the PSIs are being sent to our office by probation and parole. So, I mean, when you get it, do you want to send it to us or do you want us to contact probation and parole and talk with them?
We have contacted them and asked them to send them to the attorneys. So if that's not getting done, then I don't know if your request would be any better than mine. I mean, it might just be that when I get them, I can just send them to you.
Robin, are
that's-
you sending them to us?
What's that, sir?
Are you sending the PSIs to us?
I have sent them to the judge's office.
Okay,
I can send them to you if you need me to. That would be fine.
please.
Yes, as well, please, Robin. We're getting them from Chrissy, but it would be nice to get them too.
Okay, I can do that. No problem.
All right. So they can just be sent directly from probation and parole to the Commonwealth and to Defense Counsel, and that would cut us out of the middle.
Yes,
That's
sir.
fair.
No problem.
That'll work. All right.
Thank you.
We're gonna send it, Mr. Britt, we got to send this one out. I know you've seen it, your attorney's seen it, the Commonwealth has to look at it. So we'll call you back up in a minute, okay? I'm sending this down there to them right now. Uh-oh. Yes, ma'am. Just Robert Horton. I'm not entirely sure why this is on.
I'm not either, Judge.
That makes three of us. That makes three of us.
Yeah, I think, I mean, there's already been a hearing and that occurred back in February. And he is not on the regular docket. He's on the add-on docket. So I probably, the jail got with the clerk's office and asked them to add him or something because they thought he was supposed to be on something, but he wasn't on the clerk's docket. So Mr. Horton, I don't think we got anything we need to be doing.
This is Robert Dale Horton, is that correct?
Yes, ma'am.
Okay.
All right, you can have a seat then, I guess.
All right, thank y'all.
All right.
I know there's Robert Jr. Horton. I don't know if he was the one who should have been put on. I don't know.
All right. Yeah, I mean, we had a hearing a month ago and so his case is, I mean, he's a state inmate. Couldn't do much with it if I wanted to. Jennifer Jones. This panoply of cases is on based upon the motion of the Commonwealth filed in January to revoke probation. That motion was supplemented on Friday with some additional information. The Mr. Gardner, I think, is the one that filed these. Not sure if he's still on or he had to step away, but oh, there he is. All right,
I'm here. Yep,
you're asking for these to be set for hearing. Is that right?
that is correct.
All right, so that'll be March 23rd at 1:30. We'll reappoint counsel from the DPA to be sure that Ms. Jones has counsel. All right, Ms. Jones, we'll see you then.
Okay.
And Judge, I'm going to step away to try to contact Bobby right now.
All right.
Judge, whenever you want to bring him up, I'm ready on Arthur Britt.
Okay, we can do Mr. Britt. All right, Mr. Spears, are you ready as well?
I am, Your Honor.
Okay, Mr. Britt, this case is on today for final sentencing. There has been a pre-sentence investigation report prepared by the Probation and Parole Division of the Department of Corrections. There has also been a sex offender risk assessment prepared pursuant to statute. Have you had the opportunity to look at both of those documents?
Yes.
All right. Were there any aspects of either of those documents in terms of the factual allegations set out therein, or the statistical information set out therein, or any other aspect that you need to address prior to sentencing? In other words, do you believe that there were incorrect entries or other false information in those?
There's quite a lot in there, but you know, I already done signed the papers.
Mr. Spears, did Mr. Britt make known to you any issues that he had, or corrections, qualifications, or anything else that he felt we should make to either of those reports?
He did not make me aware of anything, Your Honor.
Okay. Is there any reason known to any, thank you. Is there any reason known to either of you why we should not proceed with sentencing at this time?
No, Your Honor. I just asked that the sentence be done per the agreement, and then I have one more request after that, but I want to discuss at the end.
All right, Mr. Richardson, you've had the opportunity to review both of those aforementioned documents as well, correct?
Yes, sir.
Is there anything that would prevent us from moving forward with sentencing at this time from the Commonwealth's perspective?
No, sir.
All right. Mr. Britt, your attorney, having moved for sentencing to proceed in accordance with the agreement in this case, let me point out that you have two cases, 19 CR 334, in which the agreement between you and the Commonwealth called for the Commonwealth to recommend a 5-year sentence plus the possibility of costs, with a condition of the plea being that you not have any contact with the alleged victim the victim in the case, and that your time would run concurrently with the next case. The next case is 19 CR 613. And in that case, the agreement called for the Commonwealth to recommend a 10-year sentence, which by statute would be followed by a 5-year period of conditional discharge, an assessment which has in essence been completed, treatment recommendations that arise from any assessment, register as a sex offender pursuant to KRS 17.510, no contact directly or indirectly with the victim or the family, which is a little bit difficult, I think, because you all are related to a lot of the same people, but I think the victim would be the operative individual there, right? And after having reviewed the information in the pretrial, or I'm sorry, the pre-sentence investigation report, as well as the other assessment report that we've got, those sentences appear to the court to be appropriate under the circumstances, and I am therefore going to grant the request to sentence you in accordance with those. That is a 5-year sentence in 19 CR 334 and a 10-year sentence concurrent in 19 CR 613. That sentence will also have the 5-year period of conditional discharge and the obligation to register as a sex offender and complete statutorily mandated treatment. The conditions of remaining away from the victims will be part of the judgment. The fines and the court costs will be waived due to inability to pay. In the first case, it appears that there was also at least the possibility of restitution. There doesn't appear to be an actual number for restitution. So what we'll do is, like we usually do, give the Commonwealth a 30-day window if it wishes to file or propose restitution or something like that with you guys, and see whether or not that's going to happen before the judgment becomes final and not modifiable from a restitution standpoint. Okay.
Okay.
All right. So that's what we shall do. Mr. Spears, anything else?
Judge, I realize that this might be you might be very limited in what you can do, but I would ask the court to tender some kind of order or whatever they feel would be the best way to do this, to get him moved out of Barron County and into a DOC facility as soon as possible due to his medical conditions. The fact he does have to do these classes, getting him into Green River or wherever with the better medical facilities would probably be very beneficial to him in the long run.
And I think that I understand your request and the reasons behind it. I certainly don't have any objection to it. I don't have much influence, because he is, Mr. Britt, you'll be under the Department of Corrections. They're in charge of where you get placed and when you get moved there and that kind of thing. But I think I think that it is at least cognizable that we can put in the judgment that he should be transferred, out of a county facility that we recommend he be transferred out of a county facility as soon as possible. I certainly can't order it because I don't have the authority over those placement questions, but we can give them our opinion.
Okay. Sounds good.
Okay. All right.
Okay.
Anything further in this case?
Not that I'm aware of, Your Honor.
All right. Thank you very much. give these calendars to you. We're going to keep the rest of them. Lorenzo Martin.
Judge, this is my case. I filed a motion, I think a supplement as well, and request a hearing date on it.
All right, sir. Do you, I don't remember who was, who caught this one out of the DPA.
I represent him, Your Honor.
Okay. Mr. Martin's in custody right now because the Commonwealth filed a motion in January setting out a report that he had been given multiple, he had multiple phone calls placed for him to go in for treatment or for, for random drug screens as condition of his bonds, and that he had failed to appear. There was a warrant. He subsequently did appear last week for a report, and according to the U-turn folks, that was positive for methamphetamine and marijuana. So that warrant was executed and the Commonwealth supplemented its motion, and here we are. He has a pretrial in May. I don't suppose anybody wants to wait that long to address these issues. I would propose that if you all wanted to put this on for next Monday at 10 a.m., we could address these motions by the Commonwealth.
With me, Your Honor.
Rather than, you know, a 2 week, the revocation to be 2 weeks. And since this is a bond question, I'd be willing to, you know, do it quicker. All right, so that's going to be 3:15 at 10 o'clock a.m. All right, Mr. Martin, we're gonna hear these motions by the Commonwealth on March the 15th, which is a week from today at 10 o'clock a.m. Okay.
I won't find get out.
I'm not going to do. I mean, not until we have these hearings. Okay.
Okay. Cause I got a bed and everything. At Healy's in Louisville. You know what I'm saying, for rehab. Or
okay.
Whatever.
Well, and that may very well be something that we look at doing. I don't know. I don't know that your attorney knows anything about that. I sure didn't know anything about it till just now. But that's something that you all can talk and discuss with me when we come back for our hearing. Okay. All right. Thank you. Keisha Parks. This case is on for final sentencing. There having been an order to void pretrial diversion that had been previously entered in the case, there has been a pre-sentence investigation report that has been filled out. Has everyone been able to see that?
I have not, Your Honor.
Okay. I thought you might say that after our previous conversation. I don't know who. You remember who represented her at the hearing? Was this Mr. Spears?
Mr. Berry.
Mr. Berry?
There was some confusion about it because we had closed it out as hiring private, but then Mr. Berry, I believe, handled the last hearing. So I'm going to try to get him.
All right. He appears to be in the meeting, but otherwise disposed. Denise, do you know whether he got a copy of the PSI?
I know our office did. I'm checking now to see if it got sent to him as well.
All right. Well, I'll tell you what. Ms. Parks, if you want to have a seat, I got to send this down to Ms. Gardner and let her take a look at it. We'll call you back up in just a minute, okay?
All right, thank you.
Teresa. Miles Pruitt.
Your Honor, that's my motion to revoke bond. I do think I've had one pending for a while, and I just filed a supplement last week. His attorney is conflict counsel Catherine Faith from Owensboro.
Okay. Well, I tell you what, we can try to put this on Monday, and
I just had a newborn daughter. She's having complications. I was want to know if I can go home. I only missed one time.
Your Honor, if I might say.
You don't have to address that. I mean,
Okay.
I've got the report in here. They've been, Mr. Pruitt, they say they've been calling you for months and you hadn't come in on any of them.
I gave him my number.
Your Honor, if
I don't live with my dad anymore because he's got Alzheimer's. He's real sick.
If I may add, in addition to that, Mr. Pruitt was, he was taken into custody on this warrant. And he was with one of the co-defendants in this case, Courtney Pruitt, as well as someone else who was in possession of a couple ounces of methamphetamine. So considering the nature of the pending action against Miles Pruitt in that situation, we definitely have some concern about him doing what he's supposed to do while he's out on bond.
I can take a drug test for you right now and I won't piss me dirty for meth. I'm sorry, excuse my language. I won't pee dirty for methamphetamines, ma'am. I promise you. I don't do it.
Listen, I understand what you are saying, all right, but we're going to set this next Monday, which is as quick as we can get in touch with your attorney and get her on here. And hopefully she can get on here and we'll talk about it then. But given the I don't have any information other than what Ms. Gardner's telling me about that part, but I mean, given the report from the attorney that they've been trying to get in touch with over a period of time.
Me and my sister live together, and I haven't been around nothing though.
I'm not talking about that part. I'm talking about not getting any tests.
Okay. So how would we go about doing this again, you say?
We're gonna have a hearing on this next week, and I'm gonna try to get in touch with your attorney so she can be here.
Okay.
I mean, she'll get on the Zoom. We'll do it on a Zoom.
Is there any way we could speed it up and I could go ahead and take my probation? I'll just take the probation instead of the pre-trial diversion. Instead of pre-trial diversion, can I just go ahead and take my probation so I can get home to my daughter?
Well, listen, I don't know. I mean, we can't sit up here and have plea negotiations without your attorney here, number one, and number two, with me being involved, and then number three, on the record. I mean, all of those are no-nos, okay? I understand what you're saying. We'll notify your attorney, and maybe I'd say that at least at some point, Ms. Gardner had been in touch with her, although I don't know how long it's been since they've talked. But I mean, she might be able to email her and tell her you're in custody, and maybe she can get in touch with you.
I'm sending her an email now, Judge. So
right.
She usually responds. Are we setting this at 10?
Yeah, I'm going to put it on at 10, and we'll do it.
Okay, I got a question. So if I speed it up and do that, will I be able to get home to my daughter faster by taking the probation instead of the pretrial diversion?
I'm going to let you need to talk to your attorney about that. I can't answer any, theoretical questions for you because I don't know what kind of agreement you all might reach if you reach any. Okay.
What's that mean? Like if we reach any, my last case was just if I go in front of the judge, it'd be a diversion.
Miles, hold on. Listen, I'm not part of your plea negotiations, so I'm saying because I don't know what anybody has talked about, whether they have made you an offer, whether you all have agreed to an offer. I don't know any of those things. All right. And we can't sit up here and talk about those things here on the record in front of everybody and recorded, because you need to talk to your attorney about those things in private to preserve A, your right not to incriminate yourself, B, your right to have confidential communications with your attorney, and C, any of a number of other rights that I'm not even going to go into right now. Okay. But I know you want to get out of jail, but that's not going to happen today. because you have, your attorney and you have to talk, and you all have to see about whether there is going to be an agreement, and if so, what the details of that are. And then that all has to get put in writing, and then you all have to tell me you've got that agreement. And that all ain't gonna happen today.
So we'll do that on Monday.
Well, if you all have an agreement, we can do it on Monday. Yes, sir.
How will I get in touch with my lawyer though? Every time I call her, she's hard to get in touch with.
Miss Gardner is sending her an email right now and telling her the situation, okay?
Yes, sir.
And she'll probably reach out to you. Okay?
Okay.
All right,
And
just hang in there.
and if she don't, what do I do?
Well, I guess we'll deal with that if it happens, but I mean, I think she probably will. Okay? All right. Thank you.
Thank you.
Ashley Reed.
That's mine, Judge. I'd filed a motion to revoke her probation if we could set a hearing date.
I'll set this for March 23rd.
Thank you.
Mr. Spears, I think maybe the last time she had a probation revocation issue, you were doing it.
That is correct, Your Honor.
All right. So the motion has already been filed, hearing 3/23, 1:30. Ms. Reed, we'll see you then.
Judge,
Oh, go
I'm
ahead.
sorry to interrupt you. I would just want to let you know that I did have the opportunity to look at Ms. Parks' PSI.
Oh, okay. We can call her up then. Ms. Parks? Thank you. All right. Mr. Berry, are you back with us? There you are. Okay. Mr. Berry, have you had the chance to review this pre-sentence investigation report?
I don't believe I have, Judge.
Oh, okay. Do you have access to it there?
I don't have it immediately.
I
What would
just
be the
sent you
best-
a new copy, Greg.
Okay.
I was going to say we can send you a copy, but it sounds like you've already had one sent to you. We'll come back to Ms. Parks in a minute. I was just assuming you had seen it. We paused her a minute ago so Ms. Gardner could see it, but
Okay.
my mistake, but we'll come back to her. All right.
Thank you.
And Your Honor, I don't want to interrupt again, but while Mr. Pruitt's in the room, I did hear from his attorney. She did respond to my email and she will be available next Monday for the hearing.
Okay. Given how far away she is and all of that, and I don't have her email address, but if you happen to communicate with her again, it might be a good idea to point out to her that I think she should talk to him before Monday.
Yes, I will, Judge.
Okay, thank you. I mean, especially, so he knows that she's checking in. Savannah Scott?
That's mine as well. We just need a hearing date, Judge.
Before I move on to Ms. Scott, let me ask you all, just to try to avoid this issue. Looks like I've got a couple of other people on here. Mr. Akers,
I've got Mr. Akers' PSI. Judge.
Mr. Felty. Those all have PSIs too. Do we need to go ahead and send you all those?
I've just gotten a bunch of emails from Micah. I think Robin has sent several.
Okay.
I know I have Mr. Sneed's.
I have Mr. Akers, Judge, and I've already read it.
Okay. What about Mr. Felty, who I think I did see on here a minute ago? Anybody need to?
Judge, that's mine. I'm checking right now to see if I've got that email.
All right. Well, I'll tell you what, if you don't, just holler at Chrissy Parker in the office in there and she could cut me out of the middle and contact her and she can send it to you. She's got them all. Okay.
Okay.
All right, Ms. Scott, you are here for, on the basis of this motion from the Commonwealth which was filed. Originally, there was one filed in September. We resolved that by drug court setback and a sanction. Subsequently, in November, it looks like another motion was filed. And so here we are, and the Commonwealth is asking for a hearing. We will set this hearing on March 23rd at 1:30. All right, thank you. Chastity Wilburn. Ms. Wilburn, you are here because a warrant was issued for failure to appear about right at a year and a month ago. And looks like about 5 days ago, that warrant got executed and you were placed under arrest. Mr. Berry, I think this might have originally been your case. I don't know if it.
It is his case, yes.
Is he available?
He's gone again.
Well, I think it might have been, and I'm trying to go by memory here, but I want to say that over the weekend, maybe a pretrial officer contacted me, and I don't remember if it was Miss Wilburn that they were talking about, but Miss Wilburn, would it have been you that they told me might have been expecting?
Yes.
All right.
Like anytime.
All right. Denise, I guess what I need to pass along to Greg, I mean,
He's back.
He's back?
He's back on.
You on here? There you go. We keep making inconsistent demands on Mr. Berry's time and attention. Mr. Berry, Ms. Wilburn here failed to appear in court back. It was actually in the pre-COVID era. She'd been kind of in the wind all this time. Got arrested last week. She's got a wanton endangerment and a drug paraphernalia. In the meantime, she has become expecting, and I under the circumstances of that pregnancy release statute and all that, I certainly would have to consider releasing her into some sort of treatment facility if that's what you all were interested in doing. She can reject that, but that would be something that I would want her to talk to you about. I would also think that maybe Bethany could conceivably at least talk to her about getting in someplace. She might, to hear her tell it, she might not be pregnant very long because she's pretty far along, aren't you?
Yeah.
What I was going to suggest is that I put her on for Monday and give you time to talk with her. I mean, I guess if you talked to her before then and she wanted to go somewhere and you all had a place for her to go, I'd let her out immediately, to go there. But I feel like I need to,
okay, Judge.
Address any kind of substance related issues as part of that release.
Okay.
Which is what the statute contemplates. Okay.
Okay, Judge.
All
Yeah,
right.
I'll get with Bethany on that today.
All right, so we'll put it on for the 15th at 10.
Okay.
And there hadn't been any kind of motion because, and the Commonwealth doesn't typically file one when the issue is failing to appear, just failing to appear in court. So, we're flexible. I mean, I don't have to have any sort of hearing before we do anything. I mean, I'll put her on Monday. I'm gonna put her on Monday on the 1 o'clock docket I don't think it really matters. I can put her on the 1 o'clock for a pretrial.
Okay.
Okay.
Okay, Judge.
All right. Thank you. Mr. Berry, whenever you're ready to do Miss Parks, I believe she might be the last person I've got in the jail docket.
That's fine with me, Judge. I reviewed the PSI.
Okay. Ms. Parks, you want to try to do this again? All right. So, Mr. Berry, you have had the opportunity, have you not, to look at the pre-sentence investigation report?
I have now, Judge, yes.
Okay, and is there anything in there? And Ms. Parks has had the opportunity to look at that too, I believe. Is there, oh, you haven't?
I mean, I filled it out.
Judge, if you want to, just we put her on at 1 o'clock.
That might be, that might be what I can do, is just ask her to have her come back on the 1 o'clock docket and give her the access to this. I mean, it's not going to take her that long to look at it, but with her being the last person we've got down there, I think we probably need to let them go ahead and go, and we'll see them again in the afternoon. Okay.
Okay, Judge.
Thank you.
All right. Thank you.
Judge, Mr. Akers, is he out of jail?
He is. He's
okay.
He's right here, present and accounted for. Kind of.
Okay, he's on call here.
Yeah. Bonnie, is that it for you guys?
I don't see him on here.
Judge, I've got Danny Neal.
Judge.
Oh, yeah. Okay.
And Mike, I have a new pending case, and then Mike has, I think, 2 that he's on probation for.
Right. I had filed a motion to revoke probation, Judge. Got 2 cases.
Do you know, Mike, if there was a motion to revoke bond? Darlene, give that to you as well.
Probably. No, I think it was just to revoke probation.
Okay.
All right. Well, I guess we better do that then real quick. All right. Do we have his phone? Huh? All right. Fair enough. All right. So the Commonwealth has got in 19 CR 164 and 19 CR 214 motions to revoke probation. In 20 CR 304, there is a motion to revoke bond, it looks like. Let me make sure he has been arraigned in that case.
He was, Judge.
Yeah, okay.
We have a pretrial in that case scheduled for June the 14th.
Okay. Mr. Berry, are these cases yours?
I believe they are. I believe they are, Judge.
First time they got me, Judge, it was driving on suspended. I didn't know my license was suspended. I just got out of jail when they got me. My wife passed away 2 days after I got out of jail, and after she passed away, I didn't have nobody to drive me. I worked for myself. That's the reason why they got me.
Stop for a minute.
Yeah,
This is the situation. All right. I mean, I understand that you are in a situation where, I've ordered you to pay money for restitution, and a man's probably got to go out and get a job to do that. I understand that your wife passed away, and, to the extent that she was able to drive you around, she can't drive you around anymore, obviously. I understand that you don't have your driver's license, and I understand that puts you in a bad situation because, of all the other things that we're asking you to do and ordering you to do. But here it is, at the end of the day, you don't have a driver's license and you can't drive.
Yeah,
I don't make those rules. Those are just the rules. If they was different, if I could make them different, I would make them different, but I can't. All right. If I could give you permission to drive back and forth to work, I would, but I can't. If I could tell you that you could drive to see your probation officer without a license, I would, but I can't. Okay. So they've got their motions. We'll set them for a hearing. The reason that
I don't care what you do. I drove on suspended license. Fuck, you let them go for beating people in Hill Golf Clubs. You don't let a man go for that. That's crazy.
Wait, what'd you say?
Just because I said I drive on suspended, but I didn't know they were suspended. Okay, I owned up to that. Okay, and now that I told you that I drove on suspended license, I left Miss Jill up here in the parking lot because my wife come pick me up the day I got out. I drove Miss Jill, didn't even know my license was suspended. 2 days
All right.
later, I get locked up for it.
So here's the situation. That's not at all what the report from the probation officer says. I was just getting ready to let you out until we could have the hearing, but you talked yourself out of it. We're going to have your hearing on March the 23rd at 1:30, and you can stay in jail until then.
Okay, you was gonna let me stay in jail, but see, you're doing it all wrong. I did
No.
not know my license was suspended, Judge, or I wouldn't have
Not
been.
true. We're going to find out, I believe, if the officer testifies to what he wrote down, we're going to find out that's not true. You've already been arrested 5 times for it. After the first time you got arrested for it. Listen here.
Bullshit. You just read
All right.
what you want to read.
I am going to do
Kangaroo
it.
court, what you got. Because you want to send people to jail for no reason. You're a liar. That's what you are. So is your fucking police. I got caught 3 times. That's it. Believe what the fuck you want to believe. You fuck.
I'm going to see you on March 23rd at 1:30.
Better get some kangaroos for your fucking courtroom, because that's what you got up there. Liars. Well, I tell you the goddamn truth.
Danny, sit down. Sit
I
down.
let you speak. You tell the truth now. You tell the truth on your fucking end.
Bonnie, do you have anybody else?
No. Judge, I have a William Taylor. He was scheduled for 1 o'clock instead of the 10. Did you need him? William Lee Taylor. They put the wrong time down.
Judge, and I think there's some confusion on that case because there's 2 William Taylors. There's William Allen and William Lee. I had William Allen Taylor, but the case number that's on the add-on should be for William Lee Taylor. It's a case that Mike has that's pending.
I was going to say, Judge, it says arraignment. It looks like he was served, I believe, back in October, and I filed the motion to revoke bonds as he had been served. And Julie Atkins had reported that he had tested positive in some, during testing.
So he's there and in your room, Bonnie? All right.
Yes, Judge, right here.